So continuing uh, to the next topic, which is mm, special rules that apply to vending machines. So the date of supply would be the date when the funds are collected from the machine. Similarly, the date of supply for deemed supply of goods or services that is the date of their supply, disposal, change of usage, or date of deregistration. So these will be the dates of supply for services, deemed supply of goods or services. So basically, this is the date of supply for deemed supply of goods or services. The date of supply of a voucher is the date of issuance or supply thereafter. So that will be the date of the voucher. Value of supply. There are quite a few considerations that have been addressed. The VAT law sets a set of rules for determining the value of supplies, while the regulation naturally provide further details on the application of principles such as when to use market value, discounts, etc. A distinction between monetary and non-monetary consideration is also made. So all of those matters will be addressed in the topic of value of supply. Output tax. In addition to straightforward business transactions where output tax is imposed and collected by the supplier, the VAT law makes provisions for special cases where output tax may also be due, such as the concept of deemed supplies. So uh, that's an easier one. Now, the input tax, the it can be a straightforward scenario, but or it can be a complex situation. So we will understand it. Input tax can be claimed on goods or services acquired to make taxable supplies, provided that the relevant supporting documentations, invoices, etc., are retained, and even the import related documents are maintained. The regulation establishes the limit within which input tax can be deducted and sets out rules for specific circumstances such as VAT recovery on goods and services, bought before the registration, as well as input tax recovery on goods held at the time of deregistration. Also, there are specific rules restricting VAT recovery on certain goods and services, including VAT on cars available for private use and entertainment. So there are special provisions for calculating input tax that is not fully incurred in relation to taxable supplies made by the taxpayer. So quite a few other aspects of input tax we are also going to see, for example, capital asset related input tax that we will also understand. Now, VAT rate, the rates of 5% of standard rate, that's the standard rate applicable in UAE. 0% is the rate applicable on certain types, including exports. So both standard rate and zero rate, these represent taxable supplies. Other others, in case of exempt supply, we neither charge tax from the customer nor we are allowed to recover input tax on those supplies. There are specific provisions for zero rate supplies, and these apply to exports of goods from UAE. There are 14 different categories: international transportation, exports of goods and services related to medicine, healthcare equipment, etc., etc., etc. 14 different categories have been identified in Article 45, if I remember correctly. Then we're talking about exempt supplies. The VAT defines exempt supplies as supplies on which VAT is not imposed. A person is not eligible to recover on any VAT incurred to make exempt supplies. Exempt supplies are listed in Article 46 of the VAT law and include the supply of certain financial services, residential buildings, bare land, local passenger transport. So all these four categories have been identified in Article 46, which is for exempt supplies. Article 42 to 45 of the regulation provide more details on the requirement for exemption. So these are explanatory articles in the VAT executive regulation of UAE. Where a person makes both taxable supplies and exempt supplies, they're partially exempt and would generally not be entitled to recover all the input VAT, all the input tax directly attributable to making of the taxable supplies can be recovered, provided all conditions for the input tax recoverability are met. All input tax uh, directly attributable to making taxable supplies can be recovered in full. Okay. The input tax wholly attributable to expense exempt supplies can not be recovered. That input tax, which is wholly attributable to exempt supplies, cannot be recovered. Special rules apply to work out how much of the input tax can be recovered on general overheads. There are in portion apportionment approaches to input tax. Registration, there are matters of registration. Any person who has a place of residence in the UAE or an implementing states is required to register for VAT at the end of the month in which the total value of the person's taxable supplies and imports, as per Article 19 of the VAT decree law, in the previous 12 months exceeds the VAT registration threshold of 375K. VAT registration is also required when a business is expected to reach the VAT registration threshold in the next 30 days. So within the next 30 days, if you're anticipated to reach or breach the VAT registration threshold, then you must register for VAT. Where, however, only zero rated supplies are made, the VAT law allows the person to apply to be accepted, and this accepted is EXCEP. So exception, the person can apply for an exception from registration. VAT law allows related parties to form a VAT group, provide certain conditions are met. So a related party refers to those parties in which one party controls the other. If a person does not give a place of residence, does not have a place of residence in the UAE or in an implementing state, and is not already registered, they must register if they make supplies of goods or services and no other person is obligated to pay the VAT, pay the tax due. For example, supplies covered by the reverse charge mechanism. So that's a very interesting and important angle. If non-resident companies are making supplies in the VAT, there is no other person who is responsible to pay, and if they they must register. They must register within the UAE. Okay, so imports are defined as the arrival of goods from abroad into the territory of the UAE, or receipt of services from outside the UAE. Export of goods outside the implementing states are zero rated, provided all the relevant information requirements are met. The transfer of own goods to an implementing state may be considered as deemed supply if certain conditions are met. We are going to look at those conditions later on. So, export of services are also zero rated when provided to a recipient outside the implementing states, subject to certain conditions. So, that's also a scenario of a zero rating. Transactions with businesses in implementing states. That's a very important area, and people get confused in this. The VAT law makes provisions for supplies made to businesses in another implementing state. The supplies of goods supplies of goods will be outside the scope of UAE VAT law if the supply is made to a VAT registered customer. So VAT registered customer can do the RCM, right? So here the memory hook is RCM, reverse charge mechanism. If the person who's receiving the good can record RCM, then the only tax that will be booked is the Saudi VAT. So the person importing the goods will book the Saudi VAT under RCM, and the seller, UAE seller, he will treat the transaction as out of scope of the UAE VAT. In another implement, services are treated as taking place at the place where the recipient is resident in another implementing state. Uh, so services, there are, two rules. In case of implementing states, where the recipient is located, that is seen as the place of supply. Services are taking place in the place where the recipient is resident in another implementing, provided the recipient is registered for VAT in that implementing state. So why is it like that? Because if the recipient is registered for VAT in that implementing state, that recipient is going to record RCM VAT for these services. In such cases, the supplier is required to include certain additional particulars in the document issued to the recipient. Okay, so tax invoices. The regulation sets out quite a few details that must be reflected on a valid tax invoice and allows the issuance of simplified tax invoice where the recipient is not registered for VAT or where the recipient is registered but the consideration of the supply does not exceed 10,000 dirham. So there is an illustration, simple illustration. Uh, Seller sells Yaz sells goods for a consideration of 7,000 dirhams to another VAT registered person. Must a tax invoice be issued for this person if it is up to 7,000 dirham? Tax invoice must be issued, but Yaz must issue a simplified tax invoice because the consideration does not exceed 10,000 dirham. So it's not a must issue, it's a may issue. If you can issue someone a simplified tax invoice, people usually want that to make their lives easier, but nothing is stopping you from issuing a full-fledged, detailed tax invoice. Returns and payments of VAT, another topic of the VAT law. Taxable person must submit a VAT return to the FTA no later than 28th day of the following the end of the tax period. The tax period is generally 3 months, although monthly returns, 6 monthly returns can be assigned in certain circumstances. So yeah, it can happen that some of the entities, larger entities, can be asked to submit monthly return. A registrant can apply for an administrative exception to change the tax period. A registrant can apply to to change a tax period. Regarding the returns and payment of VAT, so I think we discussed that 28 days is the time limit, and sometimes monthly or 6 monthly VAT returns can also happen. A registrant can apply for an administrative exception to change the tax period. If the taxpayer does not make a specific request, FTA will assign the month in which the tax period will end. So stagger groups, these are known as stagger groups, periods ending on 3 months period, uh, which which are usually beginning of the month until the end of the month. Uh, Payment of VAT is also due no later than the 28th day following the end of the tax period. So same day you have to file for the VAT return. Now regarding records, so record keeping, there is a statute of limitations, but we'll see records for all supplies made and received as well as business records, etc., must be kept for at least 5 years after the end of the tax period to which they relate. That's the default statute of limitation. Records in relation to real estate transaction must be kept for 15 years after the end of the tax period in which they to which they relate. Also, access to the records must be provided to Federal Tax Authority. Article 3 of the regulation on the law on tax procedures and Article 71 of the VAT regulation. The records in relation to real estate 15 years. Regarding bad debts, the VAT law makes provisions for a bad debt to be written off on a supply for which consideration has not been received either fully or in part, and 6 months have gone by, uh, provided the consideration you can claim bad debt relief provided 6 months have gone by, money has not been received, goods were actually supplied, even the the input VAT was also claimed by the supply customer, but most importantly the supplier has to notify the recipient that the consideration has been written off. If they don't inform, then the bad debt relief will not be possible. Certain additional conditions must be met in order for a supplier to be able to write off a bad debt claim uh, uh, for to recover from the input from the output tax that they paid. Regarding certain administrative sides like assessment, for example, assessments can be raised on tax and penalties for specific omissions, errors, and non-compliances. Who does this? FTA. FTA has wide powers to access records and perform an audit of the for the purposes of the assessment, and can take measures to seize documentation, etc. FTA also has duties towards the taxpayer being assessed, such as carrying on an audit within a prescribed time of the day and giving notice of the audit taking place, etc. So FTA also takes care of the taxpayer in that sense. The taxpayer also has rights such as verifying the identity of the tax auditor, attending the audit and duties such as cooperating and assisting the FTA in performing the audit. So all of these are responsibilities of the taxpayer. Now, regarding fines and penalties, these can be imposed on non-payment of VAT, tax evasion, non-compliance, failing to provide information, etc. Many violations. There is a very detailed list of violations provided in the tax procedures law. Objections and appeals. Now, the law on tax procedures allows taxpayers to object against decisions made by the FTA, including tax assessments. So, if something of that happens, first thing is to file a reconsideration request. The person may submit a request to the FTA to reconsider any decision or part thereof within 40 business days of the notification of a decision. Okay. An objection to the FTA's decision can be escalated to the Tax Dispute Resolution Committee. So if there is an objection to the FTA's decision, it can be escalated to Tax Dispute Resolution Committee, TDRC. Only tax disputes exceeding 100,000 in tax and penalties that are not resolved by at the committee level can be brought to the competent court. So that's if the matter is not even 100,000 dirhams, then you cannot take it to court. So exceeding 100K, you can take. So if it is up to 100,000 dirhams, uh, you cannot take it to court. If it exceeds 100,000 dirhams, you can take it to court. Uh, Decisions issued by the Committee for Tax and Penalties for 80,000 or less are final and cannot be appealed further. So final at the committee level, TDRC, Tax Dispute Resolution Committee level. So that was a quick introduction of the VAT law.